Hi, everyone. I'm Ryan Johnson, a corporate healthcare and digital health attorney at Fredrikson and Byron. Today we're going to be talking about artificial intelligence-supported clinical decision-making. Who is liable? First, a bit of background. Artificial intelligence is being rapidly deployed in healthcare to identify meaningful, complex patterns in extremely large data sets, far beyond what is capable from simple human minds. AI has learned to do what human providers do, but much more efficiently, with better accuracy, and at lower cost. AI promises to help people stay healthy, to more accurately diagnose and detect disease, and to improve clinical decision-making based upon large data sets, including lifestyle, environmental, genomic, and other factors. Now, some of the most powerful AI tools rely on machine or reinforcement learning, meaning that the AI uses simple learning rules to improve the processes or algorithms by which the program analyzes data. Machine learning allows AI programs to automatically learn and improve without being explicitly programmed to do so. In other words, with machine learning, AI can teach itself how to learn and analyze faster and better without any involvement from humans. However, in the healthcare space, these incredibly powerful techniques will often leave many unanswered questions for AI designers, healthcare providers, and patients, such as how or why the machine learning algorithms reach particular conclusions or made certain decisions. So although AI, machine learning-based techniques, may make accurate predictions, the program may be unable to explain how or why it did so, making the information medically meaningless in terms of advancing medical understanding. This lack of transparency has led some to refer to this type of AI, machine learning, as black box medicine. Now, given the inherent opacity or lack of predictability and foreseeability of black box medicine, who should be liable when mistakes are made and patients are injured? How should policymakers, courts, and other stakeholders protect patients from or provide compensation for AI-caused harm? As I will discuss over the next several minutes, the existing legal system, particularly the tort system, is not well equipped to assign liability, especially since it is largely based upon predictability and foreseeability, neither of which is present in advanced black box medicine AI. Again, the question is, who should be liable for AI-caused injuries? The AI program itself, its designer, healthcare providers, or some other party? Now let's review the basic tort law system. Most personal injury cases, including medical malpractice cases, are based upon determining whether the defendant was negligent. In order to prove negligence, a plaintiff, an injured party, must establish or prove that the defendant owed a duty of care to the plaintiff. For example, in a medical malpractice case, an injured patient has to prove that the physician or the healthcare provider owed a duty of care to the plaintiff. They also have to prove that the duty of care was breached, and that the breach was the actual and, importantly, proximate or foreseeable cause of the plaintiff's injuries, and find that the plaintiff suffered actual damages caused by the breach. Now, given the power of AI and its inherent opacity, it's going to be hard for many plaintiffs to establish some of the essential elements of negligence, particularly the elements that focus on the foreseeability of a plaintiff's injury. So again, the question is, who should be liable? Should the AI program itself be liable under tort law? Well, only human agents have legal duties. We don't hold non-humans liable for negligence or other torts, even though these non-humans often cause very painful injuries. For example, bee stings, the stubbing of toes on rocks, paper cuts, etc. Now, it seems unlikely that law will hold AI-based autonomous agents liable for the injuries they cause, at least until the AI advances to a point where it achieves sentience and legal personhood, which may happen at some point in the future, but probably not while this webinar is a top search result on Google. So how about software developers? Should they be held liable for injuries caused by their programs? The traditional rule is that software developers are only liable if they were somehow negligent or could foresee the risks of the use of their programs. But with advanced AI based upon reinforcement over machine learning, the decision-making processes and actions of AI is often not foreseeable. Now, in the healthcare settings, software has typically been viewed as a tool to help healthcare providers make decisions, with it being understood that the providers retain the ultimate authority and responsibility for final decisions concerning patient care. Advanced AI, black box medicine may, or very likely will, take on responsibility for patient diagnoses and treatment recommendations, being able to process vastly greater amounts of clinically meaningful data than a human brain, with resulting decisions being better informed and more accurate, but not always perfect, it being reasonable to assume that even advanced IA will make mistakes, resulting in patient harm. So again, who should be liable? Is it fair or reasonable to hold providers liable for decisions made or suggested by algorithms they cannot reasonably be expected to understand? Or for decisions or outcomes that cannot be predicted or foreseen? Without predictability or foreseeability, how will the current legal system hold AI developers or its users liable for unforeseeable risks and injuries? How should it hold providers liable for these unforeseen, unpredictable outcomes? Now, the legal system's focus on foreseeability may very well change based upon the new reality, where AI becomes ubiquitous in society, without any real ability to foresee how AI will evolve to solve problems and take action in the real world. So what should providers do to fulfill their duties of care to patients in a world that will soon become dominated by advanced AI? Must they evaluate the quality of the software and algorithms? If so, exactly how should they do this? Should providers second-guess recommendations made by advanced, mostly accurate black box AI? And how will they know when to do so? There are many questions providers and courts will need to answer. This will likely be done in the near future. Given the challenge of using traditional negligence law to compensate persons injured by AI, it is possible, perhaps even likely, that the law will evolve to hold AI developers strictly liable for the injuries caused by their programs. If this happens, an injured party would not need to prove fault or negligence to recover for AI-caused injuries. Now, strict liability already applies to other inherently dangerous activities and products. The policy rationales being that manufacturers or developers are better able than consumers to absorb the cost of their products, and two, they often have better knowledge of their products' hidden dangers. Courts and policymakers will be challenged to find ways to regulate and manage AI liability inside and outside of healthcare without stifling innovation. Now, given the uncertainty of how the tort law will address the challenges of assigning liability for AI-caused injuries, it's critically important for AI developers and vendors and consumers to understand risks and allocate those risks via appropriate contract language, for example, representations and warranties in contracts between AI vendors and providers. Appropriate indemnification provisions to make sure liability is assigned as the parties intend. To make sure that both parties have adequate insurance to back up their contractual and other indemnification obligations. And also, it's important for all in this space, developers, providers, to pay attention to a rapidly evolving legal and regulatory scheme. As AI advances, the law will play catch-up. The law is largely reactionary, and the current tort system, again, is ill-equipped to deal with the assignment of liability in the healthcare setting. Expect to see developments in this space. So thank you for listening today. Again, my name is Ryan Johnson. If you have any questions, I'd be happy to answer them. Please feel free to reach out via phone, 612-492-7160, or via email, rjohnson@fredlaw.com. Thank you very much.